One of our favorite secret weapons for problem solving and negotiating is local real estate attorney Brian Lytle. In this series of Get Smart, Brian shares insights on executors.
Hi, I'm attorney Brian Lytle, and in today's Get Smart segment, we're going to talk about executors as sellers. Before getting into the specifics, I want to remind you that this is not specific legal advice. I'd need to see documents, a will, for example. This is really a broad overview to help you get started and understand the issues. In this area, we use three different contracts. On the Virginia Peninsula, we use the RAIN contract. In Richmond, we use the CVR contract. And in Williamsburg, typically the VR, Virginia Realtor contract. Each handles things a little bit differently, but all are fairly drafted for both buyers and sellers, and in that way, your Lismore and Associates agent can use the same contract whether he or she represents you as a buyer or you as a seller. Again, the specific purpose of this Get Smart segment is to focus on executors. Other segments address related topics. For example, the estate segment explains how we get to determining whether or not the executor is the appropriate seller, generally, as opposed to, say, heirs or the like. If you have any questions or need help, ask your Lismore and Associates agent, and he or she'll direct you accordingly. So what we first want to look at are the broad ways that transfers occur at death. That is, a seller or sellers own property and they've passed away. The first is deeds can have a survivorship provision. That is, the sellers may hold title with right of survivorship, and that means that if one of the owners dies, then title automatically passes to the survivor or the survivors. The second broad category is someone dies testate, that is, with a will. The idea being, so the owner has died, and how that property is going to be transferred to the new owner, which in this context would be the seller, is going to be determined by the will. Thirdly, one can die intestate, that is, no will. So testate is will, intestate is no will. If someone dies without a will, then Virginia has, the Virginia General Assembly has written a will for that person that determines who is going to inherit the property. There's also one other mechanism not listed here, and that's by transfer on death deed, and we'll explain that in a different Get Smart segment. This particular segment concerns a testate disposition, that is, with a will, and specifically whether the executor of the will can sell the property. Let me note it first, and this happens quite a bit. That will must be admitted to record. And people can call that probate, and that is, the will is probated. I mean, technically, you can have the will recorded in the land records with qualification by an executor or without qualification by an executor. Regardless, it has to be formally recorded. You can't just wave the will around and think that you can sell the property. That's not how it works. Because actually a will acts like a deed. So if we record a deed, or deed is executed and recorded, then that's the instrument that transfers title to the new person, the buyer in our context. Well, a will is just like that. A will, upon recordation, acts like a deed and transfers title to the persons named in the will. And in the legal profession, we say that real estate drops like a rock through the estate. That is, it acts like a deed, invests title in the persons named in the will. But that's not the executor, and so quite often executors want to sell the property. So can the executor sell it? Well, honestly, it depends. It sounds like a lawyerly excuse, but it really does. We need to look at the will. But so first, an executor absolutely cannot sell property unless that will is probated, as I've mentioned, and the executor formally qualifies before the clerk, before the court. And is named and appointed as the executor. There'll be letters testamentary. There'll be a number of documents. There may need to have a bond. So that executor has to qualify. In addition to that, the will has to specifically provide the executor with the authority to sell the property. Executors have no inherent legal authority to do that. The will specifically has to give it to them. And the only way to determine that, quite frankly, is to have a lawyer review it. I want to make a distinction between granting authority to sell the property and a direction to sell it. So, for example, the will may say, it'll refer to Virginia law and grant the executor the authority, the power to do it. That's different than a provision in a will that says, for example, I direct my executor to sell my real estate located at 101 Oak Lane and to divide the proceeds. If that happens, then a title is actually vested in the executor and the heirs. Technically, the lawyer word for those who inherit property, real property pursuant to a will, are called devisees. But in any event, let's just use the colloquial term and say heirs. So you may recall a moment ago I mentioned that real estate drops like a rock. It vests in the heirs. Well, if the will directs the executor to sell it, then that's not the case. It doesn't drop like a rock. Title is vested in the executor, and really the executor is the only one that can sell it. But back to our, typically the will is just going to have the authority to sell, not the direction to do it. In other words, the will really gives the discretion to the executor to do so. And that's possible, even though normally the real estate drops like a rock, because the executor has the authority to divest the heirs in order to sell it. Now, that's a little complicated, and you're going to have to get a lawyer involved, and you should do that early, because it needs to be decided on a case-by-case basis whether the will allows for it, whether it should occur, and whether the buyer's title insurance company is going to insure the property with just the executor selling. So, yes, it's possible, but we need to get involved early because it's not just an easy thing to do. Lastly, if in fact the executor is approved as the seller of the property, then the question, well, how do you list that in the contract under the parties provision? What I've indicated is the short form is assuming, say, for example, I qualified as executor of an estate and I have the power and authority to sell it and I've divested the heirs, then you can list the seller as Brian D. Lytle, executor. The better way to do it, and the more formal, long form, is Brian D. Lytle, executor of the estate of Susan Smith, deceased. Again, that's better, but most of the contracts are done online and signed by electronic signature these days. There's sometimes not adequate room in that part of the contract, and so you can't get in all of the long, better language. Here, just follow the lead of your Lismore agent, but of course he or she can contact me if there are any questions, and we'll work through that. So that's our brief segment on executor selling. It's really, again, this is an introduction. Whether it's me or someone else, an executor, the seller really needs to get an attorney involved early on in that process to thoroughly vet it, make sure everything's okay, make sure that the will's probated, the executor's qualified, the heirs can be divested, and you don't want to be doing that 3 days before closing when it comes up as part of the title search. So I appreciate you listening in, and have a great day.
Be sure to subscribe and turn on notifications for our next installment of Get Smart with Brian Lytle.